My name's Deputy Inspector General of Police, Dr. Shehu, PSC. To talk about PRAWA, Prisoners Rehabilitation and Welfare Action, we have a very, very good rapport, good understanding, and good synergy between the police and PRAWA for many years. It is an institution that concerns primarily on respect of dignity and human rights, which the police are supposed to be part of it. And also capacity building to the police to enable them to perform effectively and efficiently in conjunction with the fundamental respect to the fundamental human rights as enshrined into the Nigerian constitutions of 1999. It's very, very beneficial, and at the same time in building capacity and enabling the police officers to perform credibly when they go out to discharge their duties. The police is an organization that deals with all kinds of human beings. When they come across a police officer, they deserve to be respected by police in ensuring not only their security and safety, but also in respecting their dignity and human rights. So in a nutshell, the training and retraining we are getting from the PRAWA is to enable us have police that will function and discharge their duties in a most standard and acceptable manner by members of the public. At this juncture, I want to say kudos. Welcome to the Nigeria Police Force online training.
Today we are going to continue our class on speeding up criminal justice process and human rights. I'll be looking at Module 2. In this module, we'll be looking at understanding the causes of delay in criminal justice delivery process and your role as a police officer. This course is really very important, and I want you to pay very close attention. Now, the lesson objective is to create awareness regarding the causes of delay of criminal justice delivery process and your role in facilitating this. Now, what we are trying to do is to make us aware of some of the causes of this delay that we witness in criminal justice delivery and what we can do as police officers in order to facilitate it. Now, the expected outcome is that participants will be able to have more knowledge regarding the causes of delay in criminal justice delivery and the role of police officers in this, the role you're supposed to play as a police officer in order to avoid the delay in criminal justice delivery process. Now, criminal justice process begins with the commission and reporting of a crime and continues through the arrest of a suspect and arraignment of the suspect before a court of competent jurisdiction. We are trying to say that the criminal justice process begins with when someone commits a crime, when the crime is reported, and then when the suspect is now brought before a law court to answer for the allegations. The role of the police is very critical in determining the number of persons on awaiting trial in Nigeria and their duration in custody. What we are trying to say is that you are actually the first person in the criminal justice process, because when a crime is committed, it is you that first apprehends the suspect before, after apprehending the suspect, then investigating it before the person now moves to the next process, which is going to court. The trend of delay in the criminal justice system runs through the pretrial, the trial stage, and the post-trial stages of criminal justice system. So what we are trying to say that this delay, it begins from the pre-trial stage, even before the case goes for trial. The number of time or the number of days or number of weeks or even years that you take in trying to investigate a particular case, in trying to interrogate the suspect, in trying to gather your evidence, then before the case now goes for trial, and even including the post-trial stages. Substantial delay occurs at the stage of investigation of crime. And this is really true. When you arrest a suspect or when a case is brought to your knowledge, the time you take to investigate, you need to be very swift with your investigation, because we've observed, and even research has shown, that in the period of investigation, a lot of time is actually wasted, and this is not supposed to be so. Although in some cases the delay is not caused by you, the police officer, there are some issues, of course, that may result to some of those delays, and those ones are well understood. A section of the police known as the Criminal Investigation Department is usually in charge of investigation and detection of all crimes in Nigeria. The C.I.D. unit, very important arm of the Nigerian police force that deals with investigation and detection of all crimes in Nigeria. And of course, when it comes to investigating crimes, they are in charge of crime investigation. So criminal justice system disapproves unnecessary delays. It, however, condones delays which are necessary or desirable. There are times when those delays are necessary in order to build a solid case. But of course, there are also times when the delays are unnecessary. And of course, we need to do away with such delays. The trial of accused persons who are remanded in prison custody are often adjourned due to either the lateness in the arrival or the non-arrival of such accused in court, or dates fixed for trial. What you're trying to say is that some of the delays are caused as a result of non-appearance of accused persons. When the case has been fixed in court, and on the day on the trial date, instead of bringing the accused person before the court, the accused person is not brought before the court. What happens? Now the case will be adjourned. So inadequate court facilities and modern working equipment and tools have become another thing that causes delay in the judiciary in Nigeria. We have instances where during court hearing, when light suddenly goes off, NEPA takes light, and there is no backup power in order to allow the court to continue their hearing. And what happens? The judge will adjourn the case to a later date. Now, the police can contribute to speeding up the criminal justice delivery process in the following ways. Now, we are going to look at what the police officer can do, you as a police officer, and what the force can do in order to facilitate swift dispensation of justice. One of the things that you can do is through the use of discretionary power of arrest and caution. It is not every time that someone commits an offense that a person should be arrested, especially if the person is a first-time offender and if probably the crime that was committed is a petty crime. Sometimes you can just caution the person, or maybe give the person a community service, or just caution the person and reprimand the person and let the person go. Because if everybody is arrested for every crime committed in Nigeria, our detention facilities and our correctional facilities will not be enough to contain everybody. The police is the first point of contact the suspect or accused person has with criminal justice. The decision of the police at this point is the sole determinant of some of the things that we're going to look at now. Now, because you're the first contact that an accused person, makes with the justice delivery process, these things, of course, has other impacts and other effects. One of the things they have is that whether a person will be arrested or not as a suspect. It is you that will determine whether the person will be arrested or whether the person will be cautioned, whether the person will be charged for an offense or cautioned, like I said, whether the person will be arrested, will be detained, or granted police bail. Of course, you know what police bail is all about. It's not everybody that is going to be arrested and detained in perpetuity. Some people should be arrested and granted police bail or what we call administrative bail. What charge to be instituted, when and in which court. And this is really very important. You are the one to determine, okay, this one has committed a crime. This is the charge that should be brought against him. This is when the charge should be brought against him. And this is the court that has the jurisdiction to actually hear the case. The application of the police discretion on the above things we've listed and the facts and evidence that the decision to apply the discretionary powers is based will go a long way to determine if our detention facilities are overcrowded or not. What we are trying to say is this. This discretionary power of the police is very important. And the way you exercise this discretionary power will determine if we have a lot of people in our correctional facilities or if people are cautioned to go when they commit offenses that are not very serious. Now, the frequency of use of police bail, we're going to look at how, when, and how should you use your discretionary power of police bail in terms of dealing with suspects. The use of police bail and how frequent it is used has an impact on speeding up the criminal justice process and reducing the number of persons on remand or on awaiting trial. How you use it, it depends whether we speed up the justice process or whether our remand homes will be overpopulated. Now, police bail is free. It is very important. And in most police stations you see it, police bail is free. Let me pause and ask now. As a police officer, when you grant your police bail, do you make it free in line with the law, or do you request for something before someone is let go on bail? Also remember that someone can bring a case against you if you go against what is established in the procedure and in the regulation of the Nigerian police. However, the awareness and application of this practice is very important, like I just said earlier, very important. Equally important is the conditions attached to the award of police bail. For instance, it is important to note that the police has the powers to attach certain conditions. For instance, if you give somebody a bail based on your discretionary powers, and you need to take something into consideration, you can say, okay, you are not allowed to travel out of the state pending when we conclude our investigation. You are not allowed to go beyond this location until we finish our investigation. Or the person can be told, you must be reporting twice a week to our station, or you must be coming to our station once a week until we finish our investigation. These are some of the things you can attach to your discretionary powers to ensure that the persons you are giving this police bail will not abscond and evade justice. In deciding to grant or not to grant police bail, and in granting conditional or unconditional police bail, there are some things you must take into consideration, and we are now going to see them. The first thing is the accused person likely to abscond and not present him or herself to court on the next arraignment or court day? You need to consider that. And in considering that, you need to consider the person. Is the person a flight risk? That's the word we use. If the person is not a flight risk, of course, you can now use your discretionary power to say, we will grant you bail. The second thing is the accused person likely to obstruct collection of evidence or course of justice? If the person is so powerful that the person can now become a stumbling block for you to actually do your investigation, obtain evidences that you will use as part of your evidence that will be provided in court, then it's possible you may now consider keeping the person behind bars. Is the accused person likely to commit further crimes if allowed to go on bail? Or is the person a four-time offender? When you look at the person's history, you can be able to tell if this person is likely to commit further crime. If the person is likely to commit further crime, it means the person is now a danger to society. Then the best option may be to just remand the person. Now, lack of adequate collection of evidence before arrest, effecting arrest, is another thing that delays the course of justice. When you've not collected enough evidence and you just move to arrest someone, the first instinct shouldn't just be to arrest. The first thing is, have you built up your case? Do you have enough evidence that you can take before a court of competent jurisdiction to obtain conviction? This is really very important. And we can now begin to take a cue from what happens abroad. Only recently, we heard cases of how some Nigerian nationals were arrested in faraway Dubai, in United Arab Emirates. But they did not just arrest them immediately. The UAE law enforcement officers took their time to watch their activities, took their time to build up their case, and once they were swooped on, they know that those guys are not going to be let off the hook and they are now going to be arraigned before a court of competent jurisdiction. So it is important that you collect enough evidence before you go for arrest. Another thing that also delays the will of justice in criminal cases is lack of prompt, speedy, and qualitative investigation of crime. While doing your investigation, you must not only be swift. In being swift, you must not also sacrifice quality. What it means that you must be able to balance speedy investigation and qualitative investigation. The nature of investigation is very important. Collecting evidence. Evidence is really very important because without evidence, getting a conviction is going to be very difficult. Now, what is the capacity levels of the police, both in terms of resources available to carry out their duties, and also in terms of investigation? We also looked at this particular factor earlier in saying that we understand that the Nigerian police sometimes can be handicapped in terms of resources, in terms of vehicles, even in terms of ordinary paper to use to write a statement. Sometimes is a problem. We understand that these things are not supposed to be so, and we know that it is important for the state to effectively and adequately fund what you are doing so that you can carry out your duties very well. Okay? Another thing we're going to look at right now is the lack of robust system for management and monitoring of cases to ensure that investigations proceed in a timely and effective manner and are carried out in line with legal policy and operational frameworks governing the work of the Nigerian police force. What we are trying to say in this case is this: there should be a monitoring system and a management. Someone should be in charge of looking at the case file. Okay, now this is the case file. How fast is this moving? How slow is it moving? Is there something that can be done to be able to facilitate the swift dispensation of this case? When that is not done, you can have cases of lethargy. What happens is that probably the person investigating the case, because the person is not getting enough support in order to move on with the investigation, the person may just decide to just close the case file and go back to sleep. But when there is adequate monitoring, of course, you understand that the police officers who are in charge of those cases will like to dispense or dispose of the case as swift as possible. Lack of clear protocols and systems for communicating and cooperating with key stakeholders. This is also very important. Being able to to have some form of collaboration with stakeholders is very important, because this will also help in the swift dispensation of criminal cases. But when this synergy of collaboration is lacking, then we begin to see delays. Another thing we need to consider now is poor treatment and follow-up of witnesses. This is very important. Now, you have someone who is supposed to be a witness to a crime that was committed. How do you treat that witness? If you treat the witness shabbily, if you don't treat the witness with respect, if you treat the witness like even a suspect, a witness is not a suspect. We need to also be clear on that. When someone who is a witness to a crime is treated like a suspect, what do you think the witness will do? The witness will run away. But when you treat that witness as somebody who is important, someone who if you make the witness understand that that the evidence is going to come and give, or his confession in court is going to help in trying to, in being able to dispense of the case, or in being able to obtain a conviction, the witness will know that he or she is important, and the witness will be able to collaborate and to cooperate with you. But once you treat the witness shabbily and you treat him like a witness, what will happen is that the witness will now start running away from you, and the witness will not cooperate with you. The delay in the prosecution of cases, both by the police, the Ministry of Justice, and other prosecuting agencies, is another thing we are going to now look at. The promptness of prosecution of cases by the police, as well as providing adequate information to the Ministry of Justice and other prosecuting agencies for them to be able to carry out their duties, is also very important. These are the stakeholders we are talking about: the police and the Ministry of Justice and other prosecuting agencies. There needs to be some form of collaboration, some form of synergy. Why? Everybody is working together. But when it seems like the Nigerian police is fighting the Ministry of Justice or other prosecuting agencies, there is no synergy. What do you think will happen? Of course, the cases will begin to drag. There is also lack of adequate oversight and monitoring mechanisms When there is no monitoring mechanism, like I said earlier, when there is nobody that is watching to see how the cases progress, what will happen is that there is danger of that case dragging beyond the time when it is supposed to actually, last. So it is really important that there should be some oversight and monitoring mechanism that the Nigerian police should set up to enable people who are investigating, the investigating police officers, the IPOs. They should have people who always monitor their activities, monitor their investigation to see how they are moving. So from so doing, we'll be able to have a speedy dispensation of investigation. Now, we are going to look at the abuse of the provision of Section 35, subsection 7A of the Constitution of the Federal Republic of Nigeria. Now, Section 35, subsection 4, Section 35, subsection 5, provides explicitly the number of days you are supposed to hold a suspect. But Section 37, subsection 7, provides some, gives you a leeway that you can hold somebody in case of a capital offense. You understand? But what we have observed is that because of this provision, now most cases that are not even capital offenses are now being charged as capital offense in order to hold suspects perpetually in detention. And this is not supposed to be so. So what we are trying to say is that it is not every case that is a capital offense. So when you don't have a capital offense, why are you holding the suspect perpetually in detention? And this is one of the reasons why we are now having overcrowded correctional facilities. And this is not supposed to be so. Now, other important causes of delay in criminal justice delivery process, we are just going to list them out now for you to know. And the essence of doing this is for you to understand that some of the actions you take as a police officer is affecting the criminal justice delivery process in Nigeria. It is affecting the correctional facilities. So the essence of this course really is to see how we can begin to change our attitude towards the work that we do. See how let us understand that the work we do and the way we carry out our duties is affecting the criminal justice delivery process, is making our prison facilities overcrowded. Apart from just having overcrowded prison facilities, also understand that it is also a burden on the state coffers because these prisoners are being fed with government money. Money that probably would have been used to do other very important things, we are now using them to feed people in detention facilities. Now, inadequate legal representation for detainees is one of the things that also causes delay in criminal justice delivery process. When a detainee, when a suspect doesn't have a good legal representative, it can also cause delay. Delays occurring during prosecution stage of the criminal justice process. During prosecution, when you take unnecessary time to be able to build up your case, it can cause delays. Delays occurring during trial stages of the criminal justice process. And of course, we also listed them now. When we talked about not having enough resources for the judges to be able to do their job, it can also cause the delay. Non-attendance of witnesses at court. When a case has been fixed for a particular day, and instead of bringing the suspect before the court, the suspect will not be brought. And what will happen? Because understand also that the Constitution expressly provides that in case of a criminal case, the suspect must be present in court. So when the suspect is not in court, the case cannot go on, and that will be a reason for delay. Non-appearance of accused persons in court on the scheduled hearing date and time, thus leading to adjournment. I just mentioned that earlier. Now, lack of effective coordination and oversight of criminal justice agents. We talked about stakeholder collaboration. You are supposed to collaborate with the Ministry of Justice and with people who are supposed to prosecute this case. But when there is no effective coordination, when there is no synergy, you begin to see that everybody is working as cross purposes, and this can be an opportunity for the case to drag longer than it should. Where investigations have been properly conducted, it contributes in no small measure to effective administration of criminal justice. So before you take somebody to court, ensure you have concluded your investigation. You don't take somebody to court and while the case is still under investigation and you're looking for evidence to prosecute the case. That is not ideal. Now, we are going to now look at some innovations that the ACJA, the Administration of Criminal Justice Act of 2015, provided in order to eliminate some of these delays that we have looked at. Under the ACJA, a police officer has no power to arrest a person who has committed an offense in lieu of another. Very important. Section 9, subsection 3, provides that before taking the statement of an accused person, such a statement should be recorded in absence of such facility. The said statement should be in writing in the presence of a legal practitioner or any person chosen by the person arrested. This is very important. And this can actually undermine your case if it comes out in court that this section of the Constitution was not adhered to. What does it say? It says that before someone will write a statement, the person has the right to have his legal practitioner present or any person he chooses. Because if the person doesn't have a legal practitioner or there is nobody present with him when he's writing the statement, the person can tomorrow claim that you obtained that statement under duress or that you coerced him to make such a statement, and that can endanger your case. Section 20 establishes a supervisory framework that obliges the officer in charge of police station to report to the nearest magistrate court the case of all persons arrested without warrants. The magistrate shall notify the Chief Registry of the High Court and shall forward same to the Department of Public Prosecution. What we are saying is, if someone is arrested without warrant, you need to report to the nearest magistrate, notify the registry that there is someone in your custody who was arrested without warrant. Now, Section 74, subsection 1, provides that it is the duty of the Commissioner of Police to forward all duplicate case files with respect to indictable offences to the Office of the Attorney General for the purpose of issuance of legal advice. Now, what the ACJA did is to give some very novel and revolutionary aspects that helps in the dispensation of criminal cases. If we are able to adhere to the provisions of the ACJA, you will realize that we will not be having this problem we are having where we go to court and after going to court, the judge will say you're not serious with this case and strike it out, or the case where we have overcrowded correctional facilities because people are on awaiting trial. So it is really important that in the discharge of our duties as police officers that we explore the opportunities that the ACJA has given to us in order to ensure that we will now have a speedy dispensation of criminal cases at our disposal. We have come to the end of this class. In the next module, we are also going to look at other ways that can help us accelerate speedy dispensation of criminal cases in Nigeria. Thank you very much.